In an operating agreement, you should have many provisions that protect each business partner in the event that something goes wrong. These operating agreements should be lengthy and discuss a lot of various scenarios, including indemnification, including voting rights, including equity, and all types of things. But one item to always look for is a deadlock provision. A deadlock provision is especially valuable when you're dealing with a closely held company with two business partners who wind up in a feud or a dispute. The deadlock clause will allow for a certain remedy to take place or become available. So for example, if the parties can't work out their agreement, one of the parties can initiate the deadlock provision, which states that the other member now needs to buy that member out at fair market value. That second member might then have an option based on the deadlock provision to come back and say, either I am going to buy you out, or now I'm demanding that you buy me out. And if that second party makes that demand, the first party has to buy out the second party. That's just one example. Another example of a deadlock clause would have language and information indicating what happens in the event of a dispute. So for example, you might have a third party, which can be an accountant, a CPA, a law firm owner, whatever it may be, somebody who is listed in the agreement, and it states, in the event of a dispute, this third party will ultimately make the final and binding decision. These are ways to allow the company to move forward and hopefully be able to continue to operate and not have to liquidate.